So welcome everybody. We'll get started. Hope everybody's doing well. And today's presentation is not as much about eState as it is about dealing with domestic contracts. eState has some functionality around marriage contracts, cohabitation agreements, and we're finalizing the separation provisions. But I just want to talk about it more generally and address sort of my thinking on it, and then get feedback from you guys. So let's take the situation. Let's deal with the first situation where there's a domestic agreement, a domestic contract. So that's either, let's just take a cohabitation agreement or a marriage agreement. So what I'm going to do actually, just to show you how we deal with those, I'm just going to, excuse me for a second while I share my screen. eState handles those. I'll just show you how you put that information in. So Ben and Lauren are spouses of one another. I don't know if they're married or they're cohabiting, but so let's say there's an option when you add a spouse to put in whether there's a marriage agreement or not. There's just a checkbox for it. I'll show you if you don't do that and you find out later that there is a marriage agreement, what you can do is click on the client and his panel opens up. If you scroll down to direct relationships, this is a listing. I don't know if anybody's ever checked this out, but this is a listing of all of the people in the family tree and how they're related. And so we have Lauren here, and you'll see there's 3 dots. So that means we can open that. We go to edit, and we can change the relationship, but we can also indicate that there is a marriage agreement in place, and then click done. What the impact of that is that when we draft the will, I'll just show you, there will be a clause in the will that will reference that marriage agreement, okay, or we'll have a marriage agreement. And this is the way that I typically deal with domestic contracts, because often they have a whole bunch of provisions in them that are relevant to the succession of the person's property. There are provisions that are affected on death. But my bias is against trying to replicate those in the will. If the instructions are to just do whatever the marriage agreement says. So in this case, what the wording that defaults is this idea that it advises the trustee that they're a party to a marriage agreement as amended from time to time. I clarify that it doesn't form part of the will, that we're not actually incorporating it by reference. Instead, what we're doing is it's a binding agreement that's binding on the estate. So it doesn't have to be part of the will. It's binding on the executors in any event, presuming that the agreement is drafted properly. And then it just says, I direct my trustees to satisfy any legal and binding obligations I am required to satisfy after my death pursuant to the marriage agreement, and to enforce any of the rights that accrue to me or my estate pursuant to the marriage agreement. That's my way of dealing with it. Because again, it's an agreement that's binding on the estate trustees, and rather than try to replicate the drafting that's in that marriage agreement, which may or may not be particularly good because it's drafted by maybe a non-estates lawyer. That's the way that I would typically deal with it. Now, if there's something in there that, let's say the client says, well, I've agreed in the marriage agreement to let my spouse live in the home for a year, and now in my will, I want to let them live there for 2 years, then I would use the trust and draft a proper trust to deal with that, because it supersedes the marriage agreement in the sense that the marriage agreement only sets the minimum that is required by the client. The testator is certainly allowed to give more than what's in the marriage agreement. And so that's sort of my bias. I think we can get in trouble if we redraft what's in the marriage agreement and it's not quite what the marriage agreement says, and then you get into a fight. Well, I want the marriage agreement because that's the one that's binding, and so that's my view on that kind of use of a marriage agreement, and that would apply as well to a separation agreement as well, the same sort of thing, or cohabitation agreement. So what I thought maybe what I'd do is open up the floor and see if anybody has other thoughts on how they deal with marriage agreement, domestic contracts, for example. So I'm sure I can figure out a way to do that and unmute everybody. So let's just go to participants and unmute all. So there we go. So everyone's unmuted. So if you have a comment, feel free to jump in. Otherwise, maybe just manually mute your thing if you've got noise in the background. Anybody have any better suggestions or reasons to do it differently, or thoughts on that? I'd be surprised that nobody else does it differently, because I know that there's other schools of thought that prefer to redraft the provisions again. Sorry, somebody's got some sound in the background there. If they can just mute if you're not talking.
From a pure tax perspective, I think what's important here is...
Oh, can you hear me, Jordy?
Yeah, somebody's got some sound going on in the background. If you're not talking, maybe mute your sound. That's
there
good.
We go. So a basic question here, Jordy. In the face of a discrepancy between a domestic contract and the will, they say different things. The example about living in the home for a period of time.
Yeah.
Or any other type of discrepancy. What takes precedence?
Yeah. So I mean, the contract first. So that's the way I always describe it is that's the minimum that the testator is required to satisfy. So if they don't satisfy at least that, then the marriage contract is what is, if the marriage contract said you get to live there for a year and the will says you get to live there for 6 months, they're entitled to live there for a year because that's the contract, that's the agreement that they came to. The will can supersede the marriage agreement provided they give more than the marriage agreement, because that you're allowed to do. You're allowed to gift more money than you're required to gift, rather than it's just a gift. And so that's the interaction between the two documents, the way I see it. Because the party to a marriage agreement is always entitled to say, I want the marriage agreement. So you have to at least meet that as a minimum. Did that answer that, Blake?
It sure did, Jordy. Thank you.
Good. Often these marriage agreements have trusts in them, and they're not necessarily drafted the way trust lawyers or estate lawyers would draft them. And that does give rise to problems. It's not unusual to see a Saunders and Voce issue, or a poorly thought out residence trust. So to that degree, I mean, if you see something that's, glaringly, clearly they can stay there for a year, but they didn't make any provision for payment of expenses, you might want to say to the client, look, it doesn't make any provision for expenses. Do you want to pay for the expenses? And in which case that'll avoid a potential fight between the executors and the surviving spouse as to who's supposed to pay the expenses. So those are things that are worth canvassing. I think if you look at the marriage agreement, and it goes actually without saying, I think, and obviously it doesn't go without saying because I'm going to say it, that if you do inquire with your client, is there a marriage agreement? And that's something that we, should be inquiring about it. And that's why it pops up on the interview. We should get a copy of that agreement, because if the client says, oh, I want my home to fall into the residue and go to my kids, but the marriage agreement says the spouse gets to live there. Well, that's something, we should know about. And so it's important to review, in my view, review the agreements. Domestic contracts are important. And if you're dealing with separated spouses, making sure that the provisions and that the reference to that separation agreement is in there. It's important. It's important to make sure and to warn your client, look, you have these obligations to fulfill. So, when you're thinking about your will, we should make sure that we do that. Any other comments? There's a question here in my chat line. Let me just open that up. How far do we go as non-family law lawyers in reviewing the domestic contract? Yeah, good question, Mark. Yeah, I mean, obviously, I'm not reviewing it in advance. So it is what it is. I just say, look, I'm looking at it to see what you're required to do under the agreement. And if that's sort of as far as I go, and I say to them, look, if you have questions about what your obligations are, if it's not clear, you should go back to your family law lawyer. Like I just had one right now this week where, the client says well, I'm only obligated to pay expenses until the child is no longer a child of a marriage or whatever. And I'm like, I have no idea what that definition means. So go back and ask and the client didn't know. And he was asking me like, how long do I have to worry about this? And I said, well, you better go back and ask your family law lawyer. So yeah, I'm probably much more careful about making sure I don't do anything that's outside of my scope of knowledge. And so, yeah, I would say, if you have questions about that separation agreement, talk to your family law lawyer. So sometimes we just see things and we're like, yeah, this is a bit weird. Like there's no provision at all for, security for child support or something like that. So occasionally you see that. Any questions about, domestic contracts, marriage agreements, and how, and like I said, we're building in the one about separation agreements that'll put that in. It'll be very similar to the current marriage agreement stuff. So it should be in shortly. Any other questions before we get to insurance, as it were, about which is often a key component of these domestic contracts? So why don't I move to that, and then we'll certainly open up the floor. It's not unusual where there is child support or spousal support that's in the agreement, that there'll be security on death for that in the form of life insurance. So as an example, John promises to pay child support of $5,000 a month. And if he dies, he agrees he's going to have a life insurance policy naming the spouse as irrevocable beneficiary. Let's just say that. That's what you see. Now, that's not the right way to do it, but that's how family law lawyers do it. Because the big question is, what is the intention of that life insurance policy? So, for example, if the amount that's owing for child support is 50 grand, and the life insurance policy is 250 grand, what's supposed to happen? Does the ex-wife inherit that full 250 and only 50 of it goes to child support and she gets to keep the rest of it? Or is she a trustee for that money and in fact has to give it back to the estate? These are issues, quite frankly, that family law lawyers should retain people like us to advise on if they haven't got a precedent that deals with that issue, because it's not an uncommon claim where the child support issues have been relatively resolved. There's a small amount owing maybe, but the life insurance policy is way larger than that, and who's supposed to get the benefit of that? So those are issues to deal with. If you see that in an agreement, then that's something to raise with the client and say, look, you're bound to do this, right? I can't change this without the consent of the other side. So you may want to go back to your family law lawyer and get this clarified as to what is supposed to happen to that insurance. Because because they often use this idea of irrevocable beneficiaries, which is a whole other topic to talk about down the road. So I point that that's a red flag. That's usually the first place I go in these domestic contracts is to see what happens on death. And there's usually a provision that says, okay, so and so dies, what happens? And that's where I spend my time in reviewing these, is just saying I'm just looking at the provisions that occur on your death. So open the floor to any questions first about domestic contracts and how that's dealt with and how to deal with it and that kind of stuff. See if any questions on that.
Jordan, you mentioned separation agreements. How do you deal with those differently, since there's not specific format in the program yet?
Yeah, so I just basically this wording that gets generated by eState is pretty much the exact same thing, except that where it says marriage, it says separation. And so I just use this wording, but change it to separation from marriage. And it shouldn't be too much longer before this is just a clickable thing. And so hopefully you won't have a file before we amend that, but I'm happy to email this to you. My separation wording is exactly the same. I just plug it in. I usually put it right here, but after payment of debts. Now, the other thing is, like, this doesn't really do that much in the sense that, it's really just a heads up that, look, I'm bound by this agreement that's binding on you now, Mr. Executor. And so, be aware of it, and I'm aware of it, and you be aware of it. And if anybody, like I said, wants the wording, it's basically this wording, and maybe we'll just send it around if anybody's interested. Any other questions on that topic?
Jordy?
Yeah.
It's Kit, and I'm not going to ask about insurance because I do have some strong views on that whole what family lawyers do, but
okay.
That's like
maybe
a conversation.
We'll get to that. Yeah.
That's a conversation for another day.
Okay,
there are some ways to draft around it, but okay. Question.
Yeah.
I've had the distinct privilege and opportunity of working with a lot of clients who've moved from Quebec. And, so it's not necessarily a marriage contract. It may be a civil union agreement. So we would, I assume, simply adjust the wording here to reflect what it is.
Yeah.
Like whatever they call it. Whatever the client calls it.
Whatever the agreement is called. So, for example, I've had one where it was a court order in Hong Kong. So right. I said, I am party to a court order or subject to a court order made in the court of such and such and such and such. And I just changed that to whatever I want to call it, right? There's no magic, I think, in this language, so much as you describe it sufficiently that, that everybody can identify what it is, and really a heads up that, before you start doing anything, you may have obligation. I have obligations to other people.
And where the client has multiple wills, would this provision appear in both documents?
I personally only put it in the primary will because again, it's just a heads up. It's binding, it's not doing that much other than giving a heads up.
Okay. Thank you.
You bet. Other questions? All right, that's good. Any other comments, questions, or anything on any topic related to eState or these domestic contracts, or just generally?
Me again, Jordy.
Sure.
Any idea when your eState Academy might be up and running?
That's over to Michaela. I know we're working on it. It's close. Michaela, do you know?
Hopefully soon, Blake. I will let you know when it's ready.
Thank you, Michaela.
Michaela was very careful not to promise anything. We at eState, we have this, we have a pool, and every time we have a fine system. So every time I promise that some feature is coming, I owe $50. So that's why if we're ever sort of, you hear us talking and we're like, well, it's coming out in the future, it's, it's on our list, it's because we're careful about being fined $50. But anyway, I'm promising this separation agreement thing. So I owe $50.
Well, this is really great, and I thank you very much for this, because I have clients right now who are looking at a cohab agreement and a will, and now I just have to make sure that I send them off to the family lawyer to do the cohab first. Yeah,
that's how I do it. I mean, of course, there's no requirement for that, but I typically, if I have a preference there, I'd say go get the cohab, work out the cohab stuff, and then because that might be some of the harder issues, and if we do the will now and we put in all these provisions and they're not as they're in conflict with that cohab agreement, then we got to sort of do something differently. So. So Camila, you were asking about blended families. Any special tips on that? Yeah, I mean, if there is obviously, if you're in a blended family, a marriage agreement is very important, because it's going to set out what rights that second spouse is going to have. So, that will take away a lot of the fighting, hopefully. What's worse is that they don't have that, and then they're trying to balance the rights of the spouse, the second spouse, and the kids from the first marriage. And of course, without an agreement, and I should mention this, right? Usually one of the key factors or provisions in a marriage agreement is the waiver of the right to an election under the Family Law Act. So if the client enters into a second marriage without an agreement, without that, then that second spouse has an equalization claim, which could really confuse things when the administration of the estate is proceeding in the implementation of the will. So yeah, I would, in a blended family, I would say, please get a marriage agreement. The other thing, sometimes in blended families, I don't know if I included it in, this is just an example of a clause, but the provision here, let me just stop for a second. One thing that I might more regularly use in a blended family is if things were jointly held with the surviving spouse. Let's say some assets were held with the surviving spouse, or they designated, the spouse as a beneficiary. I'd probably include the joint and designated asset confirmation, because in that case, I want everybody to know, look, I really meant this when I made my new wife the beneficiary of, or the joint owner of this property. And I don't want people coming back and saying, well, it was done for convenience purposes or something else. So that's when I might more regularly use that joint asset confirmation clause. But blended families, right, and that's this clause here, assets passing outside the will. So just to confirm, it's I really mean it. And yes, there is this, this presumption under the Family Law Act that spouses who own things, joint tenants, really mean it. But it doesn't hurt. And certainly even better in a cohab situation where they're not legally married. So, I mean, the most important part of our job, I think, is trying to anticipate where things could go off the rails. And if you sit back and look at a blended family, we know where things are going to go off the rails. It's where either the spouse or the kids are unhappy with what's going on. So yes, and there's the other reason to use this clause is there's a recent case where it talked about PCOR applying to beneficiary designations, and Kit, is that your point there? I think it is. You know, that does make it even more important to put in a confirmation clause.
Yeah, Jordy, it is. And actually there's a very good overview, which I will send to you and you can share with everyone who's on this call. It's from Kevin Wark, who is a trust and estates lawyer, very involved in the insurance industry. He's a tax counsel for the Conference of Advanced Life Underwriting. And Kevin wrote a really good overview piece of all of the national cases where this creeping trend applying to beneficiary designations. I'll send it to you, Jordy, and then you can share it with the people that are here on the call. It's I honestly do think that that is a best practices measure now for estate lawyers. It's might be something that the Law Society should be looking at, although the best solution would be ultimately to get the legislatures across Canada to update the beneficiary designation rules to do what we do with wills, which is the onus on the person challenging the validity of the designation. They should prove that. Yeah, so I'll just send that off to everyone. Sure. It's a disturbing read.
Yeah, that's and what that point is that, you know, they applied PCOR to a designation of beneficiary, and so that's why you might want to include this confirmation in many of your wills, especially if you've got a kid being a beneficiary, for example, of a registered plan. So Camilla asked the issue about the insurance declaration, and yes, you just delete the word secondary, but you would still use it because what you're trying to do there, and let me just show you what I don't know if I have an example of it, but let's just try to generate, I don't know if I have a life insurance policy in this case, but so in our life insurance declarations, the idea is if you don't designate if you haven't sort of given it to a specific person, it generates oh yeah, sorry, I don't have a life insurance policy. Let me just add one and show you, because this is, so we'll just pick that and add, and I think that should do it. Let's try that and see. Oh, I got to keep moving us around here. Yeah, the idea is that the life insurance is going to be paid to the executors to be dealt with on the same terms as the residue of your will. Now, we typically say the residue if in a multiple will situation as the residue of my secondary will, just to make it even more clear that it shouldn't form part of probate. But what you would do is if you're just doing a single will, is you would just delete the word secondary. And I think that's all you need to do. Yeah, there's actually two places for it. And then you've got it. And then you would still use it if you had a single will, because it's still avoiding probate tax with respect to this policy. Okay, so hope that helps. And I'll go right back in there and highlight the secondary, just so everybody remembers to delete that. Other question here, and for registry system real estate, do you put in a note when creating an asset that the property is in the registry, or is it enough to rely on the definition? So I just rely on the definition that it's any property that is, you know, would be a first dealing after my death. So if you know specifically, and in most cases we would know, you can put that, you know, and specifically including, you know, PIN XYZ. So yep. You can just add that manually to the definition. I typically just rely on the general definition. So it's 1 o'clock. So I thought what we'd do is wrap up for today. Thanks for your support and questions and all of that. And we'll see you again next Thursday. If you have a quick question, I'll stick around for 5 minutes, but otherwise, thanks for all your input.